Good day everyone, this is Group 6 presentation, and today we'll be discussing about presumption of advancement as an exception to resulting trust. I will give the platform to my colleague to shed more light about it.
It's a legal principle that when a person buys a property and takes out the conveyance in the name of somebody with whom he has a special relationship and also has a duty or obligation to provide for that other person, that property is presumed under the law as a gift.
For example, if Ade buys land using his money but registers under BC's name, the law presumes that BC owns the land in trust to Ade. However, the presumption of advancement is an exception to this rule. When there is a special relationship between the parties, such as the father and the son, the equity presumes that it is decided as a gift and not a trust.
In the case of Ikete versus Suno 2004, a man bought a property in the name of his son in Lagos while he was in secondary school. While the son traveled abroad to further his studies, the father sold the same property which had done in the name of his son, to a man who had bought the purchaser. And before the son returned from abroad, both the father and the purchaser died. The son of the purchaser claimed ownership to the property as the property was conveyed in the name of his father. The court had to come in between the contention between the son of the purchaser and the father who had bought the property in the name of his son initially. The court applied the principle called nemo dat hold non abet. You cannot give what is not yours. The father who having bought the property in the name of his son cannot in turn confer a valid title to the purchaser. So the father had relinquished all valid title in the property when he made it in the name of his son. So it's not a resulting trust, but a presumption of advancement. And also in equity, where there are equal equities, the first in time will prevail. Quid tempora e potio juri.
In the case of Shepherd against Cartwright, the father purchased shares in the names of his children. Subsequently, he sold the shares and deposited the money in an account. 5 years later, he got the written consent of his children to withdraw the money, although the children were not aware of what they signed. So the court held that there is a presumption of advancement because the father is under the obligation to take care of his children, and therefore the money belongs to the children.
There are certain situations whereby the presumption of advancement will not apply. For example, in the case of Bennett versus Bennett. In this case, a mother wanted to help her son who was in severe bankruptcy, and consequently, she gave the son the money in form of a loan. Unfortunately, the trustee was still in bankruptcy and wanted to claim what was left of the money. From the evidence presented, it is evidence that there was no presumption of advancement, as the money the mother gave to the son was in form of a loan and not a gift. Also, the court stated that in equity, there is no presumption of advancement in a relationship between a mother and a son. It only occurs where the relationship between a father and a son or a male female.
It is important to note that parole of documentary evidence is an issue between what the presumption of harassment and establish that the purchaser intends to purchase the property results in trust. For example, in the case of Margaret versus Values, a house was acquired for joint occupancy for a father and a son, and the house was purchased in the sole name of the son. However, the purchase price of the house was bought in partly from the sale of the father's previous house and partly by means of mortgage.
Because of our statement that the presumption of advancement was reported by evidence on the grounds that the father had intended to retain ownership of the property.
Thank you.
Nigerian position of presumption of advancement relies heavily on the doctrines of common law and principles of equity. However, it does take into account our local realities and traditional belief systems. Its reliance on English common law is a father-to-child gift. If a father buys the property in the name of his child, he is presumed to have given that to his child as a gift. Same thing applies if he buys the property in the name of his wife. He is also presumed to have given that to his wife.